of the state?
Yes, Your Honor. The state is requesting that Ms. Markham be sentenced to a minimum of 24 months in prison.
Well,
this is
we're
not
going to sit here until you understand, or until you at least acknowledge.
This is her first OVI.
And Your Honor, I had the day off of work.
Say what?
I have the day off of work. I can.
I think it's appropriate for me at this time now to terminate the Faretta inquiry, deny your request to proceed pro se. I'll specifically find that the request is not a genuine attempt to present a legal defense, but a calculated strategy to obstruct and subvert the court's proceedings. The defendants utilizing rhetoric of what would typically be called a sovereign citizen movement, including raising nonsensical challenges and attempting to apply commercial law to criminal prosecution or equitable law.
No, that's not
ma'am, you
true.
keep saying no, but you're talking over me and I don't know.
Defendant is pro se. State is represented by Deputy Prosecutor Hammer. We were set today for, I believe it was a Faretta hearing.
It is Faretta. Mr. Allegretti wants to represent himself. Sir, did you get a copy of our pro se representation form?
Yes, I did, Your Honor.
Did you have a chance to review that?
Yes.
Do you sign it and stuff?
No, I did not.
No? Do you have it with you?
No, I'm not going to sign it. I'm here, if I may speak, Your Honor. I'm appearing in persona, propria persona, especially not generally. I do not submit to the jurisdiction of the court as a defendant.
Okay, Mr. Allegretti, that's all you need to say. If you're not going to submit to the jurisdiction of the court, you cannot represent yourself pro se. I'll appoint the Porter County Public Defender Service to represent you.
No, I
and you will
cannot
have
finish
counsel.
talking.
I'm sorry, sir. What you're saying is that you will not subject yourself to the jurisdiction of the court. What that tells me is that you're not capable of representing yourself, because when you represent yourself in this court, you become to the same level as an attorney, okay? Because you are unwilling to subject yourself to the jurisdiction of the court, you cannot hold that status. Do you understand, sir?
No, I do not.
Well, that's all you need to know. I'll appoint the Porter County Public Defender Service to represent you. You're welcome to hire counsel.
I will not be accepting that, Your Honor.
You are accepting it, sir. You know what direct contempt of court is, sir?
I wanted to put my other stuff on the record, if you don't mind.
I will not allow you to put any garbage like what you're about to say on the record.
Okay.
You have filed documents in front of this court. You have boogered up my court docket with your pro se filings over the last couple of weeks. I've had to write orders that struck those from the record. None of that is of record because it was stricken. And I have your mail here that you apparently don't even have the correct address for the court. What's your address, sir? Do you know what direct contempt of court is, sir?
Yes.
Direct contempt of court is when you are in contempt of these proceedings. And one way that you can be in contempt of court is if you refuse to answer questions and you delay the proceedings in front of this court.
Yes.
And you're refusing to answer questions that are as simple as, what is your address? And we need to know the address for the official court record. You understand that, sir?
Yes.
What's your address?
7021 Square, Indianapolis, Indiana.
What's the zip code?
46260.
Just so you're clear, do you know what the penalty is I can give you for direct contempt of court?
No.
Up to 6 months in jail with no good time credit. You understand that?
Yes, Your Honor.
Okay. So you're clear, I struck your frivolous proceedings from the record a few days ago. Officer Ball, can you give him this? Sure. In that, I wanted to make sure that you were explicitly warned that, well, firstly, I'll consider this conduct during the Faretta hearing as evidence of an inability or unwillingness to abide by the rules of procedure, which may result in the denial of your request to represent yourself, which I have already done. Okay, so I denied your request to represent yourself. I've appointed counsel for you.
I do not understand those.
What'd you say?
I don't understand this proceeding, and I don't understand the charges.
I'll get back to that in a minute.
Okay.
The second thing I notified you is that I may exercise my inherent authority to impose filing restrictions on you to prohibit you from filing any future pro se documents without prior judicial screening and approval. I've taken care of that because I've appointed counsel for you. And you're not allowed to do what's called hybrid representation. You're not allowed to also file things at the same time your lawyer's filing things, because they're responsible for anything that would come to this court. Do you understand? So any motion
I do
that
not
they would
understand.
file. What did you not understand the words I used or what they mean?
Everything.
What's your level of education, sir?
I didn't. I had some college.
Okay, so you graduated from high school?
No, I did not have a GED.
You have a GED? So you graduated from high school? You have a equivalency
Yes.
of a high school graduation?
Yes.
Okay. So what I said was that you're not allowed to do hybrid representation. Do you know what hybrid means?
Nope.
Hybrid means that there are two ways, right? Hybrid would give the understanding that you're also representing yourself pro se at the same time you have a lawyer.
I do
Understand
not
what
have a
that means?
lawyer though,
I just appointed a lawyer for you.
but I don't want it.
You have it because I denied your right to
I can't
represent
afford
yourself.
one, and I don't want a court-appointed attorney that's represented under the Bar Association.
Sure, the first words you told me was that you don't plan to submit yourself to the jurisdiction of the court. As a result,
I wasn't able to finish.
I
said as a defendant.
well, sir, you have to submit yourself to the jurisdiction of the court. That's the kind of nonsense that I think you're involved now with some program that you probably don't want to be if you want to try to represent yourself in front of this court. But in any case, the third thing I told you is I can impose further sanctions for contempt or abusive litigation practices upon you. You understand what that means?
No, I do not.
I can hold you in contempt of court for delaying these proceedings, and I can sanction you for abusive litigation. All right? And the fact that you've now tried twice to file the documents that I've had to strike from the record tells me that you're willing to be an abusive litigator. Do you understand that?
I do not.
Okay, so I have time that I work on cases. Everything is pretty streamlined for the most part. People understand how the rules work. When they represent themselves, they make themselves apprised of all those rules, and they're held to the same standard that lawyers are held to. As a result, things run fairly smoothly, and we have some thousands of cases that we handle each year. Because people follow the rules, they abide by our processes, we're able to get our work done in a relatively streamlined fashion. What you're suggesting to me is that I shouldn't do that. What you're suggesting to me is that I should, for your specific case only, have some special rules and allow you to somehow opt out of your given name, opt out of the processes and procedure of this court, and allow you to proceed as your own sovereign or something of that nature. Is that correct?
Yes, Your Honor.
Correct. Right. And we can't have that. You know
Your
why?
Honor, but if you
Because
just let me
it
finish.
doesn't follow the rules of court procedure. And
But I'm in
court
equity, Your
is
Honor.
going to follow the rules of court procedure. And if you want to abide by those procedures, you'll be fine. If you don't abide by those procedures, you'll be in contempt. You understand?
I still don't understand the proceedings and the charges of this matter.
Okay, let's go through the charges again. I had an initial hearing with you. Let me see when I had the initial hearing. Back on November 3rd, 2025. And at that hearing, I went through all the charges with you. And I made sure at that hearing that you understood all three charges that were filed against you. And you acknowledged each and every time I went through a charge that you understood both the charge that's alleged against you and the potential penalty for that charge. You do not recall that hearing, sir?
I recall the hearing, but I still don't understand the charges of the natures or the proceeding.
Okay, sir.
I just want to put that on the record.
Well, we're going to sit here until you understand, or until you at least acknowledge you understand. And if
That's
you don't,
fine, Your Honor. I had the day off of work.
say what?
I have the day off of work. I can stay.
Okay. So count one says that you're charged with dealing cocaine. It alleges that on or about September 28th, 2025, here in Porter County, you did knowingly or intentionally possess with the intent to deliver or finance the delivery of cocaine or narcotic drug, and the amount was at least 10 grams, contrary to the form of statute. You understand the charges in count one?
No, I do not.
What do you not understand, sir? The words I used or what they mean?
What is the definition of understand in the law?
Sir, you have to just acknowledge whether or not you understand.
I don't understand, though.
Which part do you not understand?
I don't understand all of it.
Okay, well, let me go through it again. Count one suggests that you dealt cocaine, a level 2 felony. You understand what a date would be, September 28th of 2025?
I still don't understand.
Sir, do you not understand what date would be September 28th of 2025?
I accept your date, but I don't understand the natures of these charges.
Okay, sir, you're about this close to being held in contempt of court. You understand that?
I understand, Your Honor.
And if you're held in contempt, I'm going to put you in jail, sir. And I'm going to jail you.
Why are
until
you
tomorrow.
forcing me to understand the charges?
I'm not forcing you to, sir.
Yeah,
I'm just
if you're just going to give me an
trying to
attorney.
go through the statutory and constitutional procedures required of me in this court. And that's for me to make sure you have a knowing and voluntary, well, not knowing and voluntary, but you have an understanding of the charges filed against you. It's part of your constitutional requirement.
And if it is, I do have rights too, right?
Well, I've gone through your rights with you. You understand that you have certain rights in this case?
Yeah, do
I'm
not.
required to advise you of your various rights in this matter.
Am I
You have the
allowed?
right to hire an attorney to represent you. You understand that?
And I do want an attorney.
Well, you understand that you have the right to one, or you wouldn't be able to suggest that you don't want one, correct?
I don't want one.
So you
I don't
understand
want-
you
I
have the
don't-
right to one, correct?
Correct.
Okay. And you understand that if you can't afford one, the court will appoint one for you, correct?
If that's what you say.
Oh, no, sir. You either understand or you don't. You understand?
I understand that you want to give me a court-appointed attorney.
No. I already appointed a court-appointed attorney for you because you can't get through the Faretta hearing. You understand why you can't get through the Faretta hearing?
No, I do not.
What were the first words out of your mouth when you read off your card earlier?
I said I'm in propria persona,
And then?
especially and not generally. I do not submit to the court's jurisdiction of the court as a defendant.
And that's all I need to hear, sir. That's all I need to hear. Because if you're not willing to submit yourself to the jurisdiction of the court, you cannot represent yourself in front of this proceeding. Do you understand that, sir? You know what jurisdiction is?
Yes.
Tell me about it.
You think that you have jurisdiction over my body and I'm a living human
What does it
being.
mean, sir?
Are you here to practice court? I don't understand what this has to do with anything.
I'm asking the questions, and I don't care whether you think you understand it or not. You've come up here with your sovereign citizen
I'm not a sovereign citizen. I did not claim to be a sovereign citizen.
trying to bring
I'm using the law in equity.
confusing sort of pseudo-legal jargon into the court, arguing things that aren't even based on criminal law.
I didn't even get to
and
finish my
suggesting that
statement.
you're not willing to subject yourself to the jurisdiction of the court.
I didn't
As a
even-
result, you can't have a lawyer. I'm sorry, you can't represent yourself. You have to have a lawyer, somebody who understands how the court proceedings work and is an officer of the court already. You understand that?
No, I do not.
Which part don't you understand, sir?
Everything. I can't even state my statement. I want to just put my statement on record.
What's your statement?
Why is that so hard to?
Because the first part of your statement, this is a Faretta hearing. I'm here for a Faretta hearing. I've already denied your Faretta rights based on the very first words that came out of your mouth, which was that you're not willing to subject yourself to the jurisdiction of the court. If you're not willing to subject yourself to the jurisdiction of the court, you're not capable of representing yourself, and you must have counsel.
I said as a defendant, Your Honor.
Sir, I don't care how you try to qualify it. So I've appointed counsel for you. I was going through the charges in count one, but I needed to find something here. I took some notes the other day related to your case, and I wanted to make sure that we had that as well. All right, sir, do you understand the allegations in count one
No, I do not.
related to the possession of cocaine?
No, I do not.
Okay. I'm going to give you another chance to explain to me what do you not understand.
I don't understand the charges. I don't stand under the charges. If that's what we're talking about, I do not stand under these charges.
I'm willing to hold you in contempt, and we can handle this again tomorrow, okay? So what I will do, Mr. Allegretti, is find that you've unduly delayed these proceedings.
All I want to
Find you in direct contempt of court for your continuous delay of the proceedings. I'll sentence you to a day in the Porter County Jail for your
Honor, I
contempt.
have a job.
Please take Mr. Allegretti into custody. We'll try again tomorrow, sir. We'll be adjourned in F2 10947. And I'll open a new case on the contempt proceeding as required by rule.
Yes, I filed a motion for a special appearance.
Yeah, that's meaningless to me, sir. And I struck that from the record, so it's of no moment.
Indeed, I object.
Noted. So I'm just going to set you over, Mr. Purple. Is that what you need?
Yes,
Some more time?
Yes.
Yeah. Guys, he was just sitting on that other date.
Okay.
All right. We'll see you back here on the 29th of May, sir.
Thank you.
Prince Pugh, stay, would you please start a record?
Yes, Your Honor, thank you. This is State of Indiana versus Prince Pugh. The cause number is 64D012305, ISO F54448. Defendant is present in court in person by video conferencing, is here with counsel, Mr. Steve Provost, State of Indiana by Gary Gurman.
I think it's an F6, though. That's just a typo. It's definitely 2305 F64448. Morning, Mr. Pugh. Can you hear us okay?
Yes.
Okay, thank you. Mr. Provost?
Your Honor, I don't have anything new to report to the court. I haven't been able to see Mr. Pugh since he was rearrested on this matter. However, I have reviewed the pleadings that Mr. Pugh has filed, and I guess I'm looking to get some clarification from the court and Mr. Pugh as to my office's involvement in this matter, Your Honor. From what I've read, it appears Mr. Pugh is desirous of representing himself in this matter and has filed his own pleadings in accordance with that desire. But I want to be clear if, in fact, that is what he wants, and if my office should be withdrawing from this case.
Well, what happened was I entered an order striking some pleadings back in November. There were some more pleadings that were filed. I struck those in last week. And then there were some more pleadings filed, and I have a motion, or an order rather, that strikes those. But while it was in the work queue, some more motions came in. So I needed to work on the order to strike the additional pleadings that came in. We don't allow for hybrid representation in this court, Mr. Pugh. So I've appointed counsel for you, and you need to file anything that would come to the court has to come through counsel. You can't file things on your own, sir. You understand that?
No, I do not understand that.
Okay, well, that's how it is. So anything you need to file has to come from your lawyer. And if it doesn't come from your lawyer, I will strike it from the record because we don't allow what we call hybrid representation. Okay?
I object.
Okay, we'll note your objection for the record, sir.
Your Honor, do we need to have any discussion with Mr. Pugh on whether he wants to proceed pro se?
I don't have a motion from him to proceed on his own and without counsel.
May I ask, I understand you're not going to address it today, Your Honor, but just so I'm clear.
I mean, he hasn't filed that motion.
Yes, I filed a motion for a special appearance.
Yeah, that's meaningless to me, sir. And I struck that from the record, so it's of no moment.
Indeed, I object.
Noted. So I'm just going to set you over, Mr. Purple. Is that what you need?
Yes,
Some more time?
Yes.
My Honor, are you aware that the respondent is a national citizen to the United States of America Republic, which is a sovereign government that has its own jurisdiction? Is the court aware of that?
Mr. Pugh, I'm going to set your case over for a few weeks to June the 12th at 8:30. I'll have you back June the 12th at 8:30, and we'll see you back here then.
I object.
Noted. This denied that you want to subpoena Dwayne "The Rock" Johnson. I don't believe he's going to have anything relevant to talk about at the trial. We'll make sure this gets uploaded as well. I need that stamped as well. That needs to go in there too. Wasted a stamp on that one. Okay. Good?
Oh, yeah.
Okay.
Well, how's come last time, I tried to ask them if I could turn something into them through the correctional office. They told me they just fed me a story that they gotta ask somebody if they can or can't do that, and they tried to act like I wasn't allowed to do that.
I don't know. I generally believe that when somebody tells me something like that, that there is some sort of administrative process they have to go through to actually do the thing that you're trying to get done, because they're trying to protect and keep people safe and all this.
So what if I try to get them to do what you just asked me to, and they tell me no once again?
Well, I think they're going to understand that I asked you to, right?
Well, they didn't understand last time.
Did you invoke the power of Judge Fish and say, Judge Fish told me to ask you to do this?
Yeah, I told them that. And
Okay.
they wouldn't allow
Mr.
me.
Hammer, you want to approach and police this up?
Yes, Your Honor.
Yeah, I'm staying right here. We're adjourned, but I got another hearing, so you're free to go. Thank you, sir. Yeah. Yeah, you can take as long as you need. I want to note a couple things for the record. Ms. Butler, I received a pro se filing from you yesterday. There were some documents and things mailed to the court. Do you recall doing that? You recall sending this to the court?
I sent it to the young lady, yes.
Okay, so I am going to scan this, put it up into your file, but I just want to note for the record that
Yes.
we don't permit what's called hybrid representation, okay? So you have counsel, you can't also submit matters on your own behalf. Anything you want to submit to the court, you have to submit through your attorney. Do you understand that?
Yes,
You do understand that?
yes.
Okay, and then the matters that you submitted aren't matters that we understand in this court. You submitted what we refer to as pseudo-legal jargon, or matters that are contractual in nature and have nothing at all to do with a criminal court case. So I'll upload them into the case, but I'm also going to strike them from the record. Okay? Just so you're aware.
Mail that to the clerk. I didn't mail it to, that's private that you have, the documents that you have.
Do you have another case pending somewhere in the court system other than this one?
It's just this case here.
Okay.
Those was private documents. It wasn't for public only.
Is this something you want to file with the clerk?
No, it wasn't filing with the court. No, it wasn't supposed to file with the court. It's supposed to file with the head clerk, Jessica.
And are you trying to file a case or something other than in this case?
It's referring to this case, yes.
Okay, so
Yes.
we'll upload them into the file and strike them from the record, as I mentioned. Let's get a trial on the calendar. Mr. Prosecutor, how many days you need to try this case?
Judge, I believe 2.
And let me say something. Because I'm not being represented and I'm not, my evidence is not being presented like it's supposed to be. Yeah, because you're not helping me. Would I be able to say something? Okay.
All set trial by jury on August 18th and 19th. So Ms. Butler, I set you over for a jury trial on August 18th and 19th, 2026. If you fail to appear for your jury trial, I'll hold it in your absence, and you can be convicted even if you're not present. You understand that?
I comprehend.
We're adjourned.
Your Honor, before we adjourn,
Can you grab the mic?
Before we adjourn, Your Honor, I know Ms. Butler wanted to make a statement if court would allow that.
Okay, go ahead.
How you doing? The reason why I might have to let Mr. Pribble go because I'm not being helped with my case. There's a lot of violations that happen towards me. There's a lot of my evidence has been tainted, and it's a one-sided case. There's a lot of due process violations that occur, and no one want to listen. Everybody's being selective-minded, and I just want to address that to the court. I have so much evidence that I have presented in this court to show you, to prove to you, show facts, and also show you there's a lot of concealment within this court. So I'm asking you, can you address somebody to assist me in that matter?
Ma'am, we appointed the Porter County Public Defender Service, I believe, to represent you. Are you in this matter privately, Mr. Pribble?
No, I'm not.
So we appointed the Porter County Public Defender Service to represent you, ma'am. I appoint them and then they appoint a lawyer. So you've got Mr. Pribble involved in the case. You can't pick and choose what lawyer you get when you ask the court to appoint counsel for you. You get what you get.
I get that, sir.
Okay?
But only thing, the reason why I ask is because I feel like I'm not being helped. I see like I can do it myself and present this as pro se, but evidently it's just being delayed continuously.
Well, ma'am, if you want me to do what's called a Faretta hearing and make a determination whether you can represent yourself without counsel, are you prepared to do that?
Yes, I am, sir.
Okay. I mean, I can do that Faretta hearing, but I'll let Mr. Pribble go for the day, and I'll hold you until we're completed with the rest of our business. I'm not going to make all these other people wait while I go through a Faretta hearing with you.
Can I come back?
Come back when?
What time is it? Around 12:30?
Oh, no, ma'am. I don't have time at 12:30, but I have time around 11:30. Did you have a chance to review the pro se waiver rights form I presented you in open court?
I looked at it a little bit.
Did you sign off on that?
No, I did not sign off on it yet.
Okay. Would you like to have more time to review it before you sign it?
Yes. Can I get the second page, please? Because I have written on the back of it. You have
I'll give you
you
a
have
whole
a spare. I'm just gonna give me a whole new one. Can I also address something? You just let me know when I can.
Oh, go ahead.
When we spoke earlier about the document that was submitted, I just want to inform you that the head clerk is aware of it. Since May 11th, they've been working with me, providing me all the accounting. What you just gotten just now, I think one of your staff did not follow the correct procedures. So I was going to let you know that my estate has not been abandoned. I also want to let you know that I did not appoint anyone to administrate my estate. So, for that being said, I'm coming here with honor, clean hands, and no controversy. I do not want to argue about anything. I just want it to be settled, closed, and gone.
Okay, ma'am. Anything else?
When you do present another date for me to come in, would I be able to talk about this matter? How this all led up to, because I really never got a chance to even speak to no one. I've been
Ma'am,
silent.
that's what the jury trial's for, okay? All the facts and circumstances related to the case, the state's evidence, everything of that nature would come out during the jury trial. So I need to go through this Faretta hearing with you, ma'am.
Okay.
You've indicated you want to represent yourself at trial. You have a right to do that, just as you have a right to have counsel present and have a court-appointed counsel if you can't afford one. But before I make that decision final, I want to make sure you understand what you'll be giving up. You understand you may have a number of defenses which apply to your case, which an attorney is trained to know. Do you understand that?
I comprehend.
Okay. And do you realize that if you were convicted of the offense in this case, that you're facing a possible penalty of 2 level 6 felonies? So each one of those would carry between 6 months to 2.5 years in prison. So the total combined penalty could be 1 year to 5 years in prison. Do you understand that that's the possible penalty?
I comprehend that as well.
You realize there are factors the court can consider in increasing your sentence within that range or in decreasing your sentence within that range, and that those are called mitigating and aggravating circumstances, and that a trained attorney knows how to identify those and present those to the court?
I comprehend that.
Okay. Attorneys have developed certain skills in, an attorney can also evaluate the strengths or weaknesses of the case against you and give you expert advice on whether you should attempt to seek a plea agreement with the state, which may result in the dismissal of some of the charges and a recommendation for a favorable sentence in return for your plea of guilty. Do you understand all that?
I comprehend that.
Okay. You must understand if you decide not to have an attorney, you will not receive any special treatment with your defense. You have to follow the same rules and procedures in your case as an attorney would have to do. you understand that?
Yes, I comprehend that, so.
Okay, so you filed these documents with the court, and these documents make statements about an Office of Executor Observations,
Mhm.
findings regarding Porter County Superior Court interaction with Tierra Lene Butler. You talk about final order to settle and close,
Yes,
different things like this. And then
Yes.
there's like a recitation of chronology, different things of that nature. And a few minutes ago, you mentioned something about how the clerk's office is helping you like settle your accounts and different things of that nature. You understand that those aren't themes or processes that are part of the criminal court proceeding?
well, I had did some research on my case, and I noticed that I had in a
Oh,
high,
that's not the question I asked.
no,
I think you misunderstood the question.
it's not criminal. It's not criminal.
Oh, you're here in a criminal proceeding. Do you understand
Yes,
that?
yes, I am in a criminal proceeding, but like I've been trying to explain, ever since when I had,
Well, I need you to answer the question I asked you.
Okay.
Okay, which was whether you understand that these documents and things that you follow with the clerk's office, what's the receipt date on this?
it should be April 16th or 15th.
April 16th it was received, so just yesterday.
Mhm.
That these aren't criminal matters that you followed with the court?
Mhm. Those are criminal matters, the violations that have been held against me. Yes, that's a lot of
You
violations.
understand they're not, though. I mean, these aren't things of a criminal nature that would be part of this criminal case.
Well, you saying what I just filed is not what criminal?
This
Explain a little bit
document,
clearer.
these papers seem to indicate that you're trying to proceed in equity or under
Yeah,
some
that's
sort of
what
a
it is.
pseudo legal jargon, some type of a,
Is we in the Article Court 3 right now?
say again?
Are we in the Article Court 3 right now?
I don't understand what you mean. This is the
Means
Superior
that,
Court of Porter County.
okay, so we basically still in the same court as administrator. So you're basically trying to administrate a mistake. But I was letting you know.
Okay, Ms. Butler, you understand that these administrative things that you're talking about aren't part of this court proceeding?
I know, I'm aware of that. I was talking to myself. But what I'm saying is I have done some research, okay? And I actually wanted to address it. And I'm not getting no assistance with the public defender, okay?
What are you trying to address, ma'am?
My innocence of the matter, and also the violations, the due process, the unverified information, the lying, the evaluation. I've been forced to be drugged without a cell hearing. My evidence that was held from me when what's his name? Jeffrey Clymer had ordered the prosecutor to meet me in private to see my documents. I mean, the evidence held against me, and he refused to present them to me. That's a brandy violation because it worked in my favor when I first got it. Then also
Ms.
on the
Butler,
record.
I'm trying to get you through this
Hold on.
Faretta hearing.
I know,
okay?
but you asked me, and I'm trying to explain the violations, okay?
Right, but those aren't violations that are
They are.
part of this court proceeding.
Now, on this court proceeding.
If you have something that you plan to file related to that, it has to be filed through your attorney because you
And
still have attorney.
I did that too. You know what he did?
I don't know, ma'am.
Ignored me.
What you have filed through the clerk's office, you're saying are that matters in equity. We don't recognize what you're talking about in
You
these
asked-
filings.
This is a bank. This is a bank. I understand how the
What'd you
court-
say?
This court system operates like a bank.
Okay, it doesn't, ma'am. This
It
court system doesn't
operates.
operate like a
Yes,
bank
it
in any way whatsoever.
Hold on, let me finish.
No. I'm not gonna let you finish that
Okay.
particular
I
statement.
said I want to
Because
preface
I
this.
just
Don't
need-
want to argue.
I need
anything.
you to,
I just want you to
redirect-
understand me mentally.
I did the mental thing just fine.
Okay.
I'm not worried about any mental thing.
Okay.
What I'm worried
okay.
about is the conception you may have that this is some sort of court of equity or some sort of a business transaction, some sort of a bank, something of that nature, because it is none of those things. You realize that? This is a criminal court.
Yes, it is. This setting is.
We're not an Article 3 court. That's a federal concept.
Yes.
You understand that?
Yes, I am.
Okay, we're an Article 7 court, if you must know, in the state of Indiana, separate judicial branch,
Yes.
not any of the things that you've said here.
Yes.
So what I need you to tell me is
Okay.
whether you are understanding that you have to follow, if you're going to represent yourself, you have to follow all the rules and regulations that are promulgated by the courts of Indiana. You have to follow the criminal rules. You have to follow the trial rules.
Yes.
Will you do that?
Yes. Yes.
You
Yes.
will do that.
Yes.
So you understand that what you filed yesterday can be stricken under the record. Under the trial rules, under Indiana Trial Rule 12F, because it's impertinent to anything that is going on in this proceeding. You realize that?
I understand that in a sense, but like I keep explaining to you, it was not supposed to be filed in the court. That's the difference.
You filed it at the clerk's office.
Yes.
Well, let's carry that out for a minute.
Yes. It's a difference.
What's the name of the clerk's office?
The court's office is the clerk of clerks. Clerk of clerks.
Clerk
Yes.
of courts, right? So there are
Yes.
clerks. So if you
Yes.
file something and you have a case pending, they send that to your case. Unless you try to open a case of your own,
No.
you're trying to open litigation of your own.
No.
Okay.
What I am.
This has to be presented in your court case here that you have pending before us.
Okay.
you're
So
telling
you will
me
not
to
strike
follow
it?
the rules.
You won't strike it down, or you will strike
Oh,
it?
it has to be stricken. It is impertinent to anything we're doing here. You understand?
No, I don't understand.
Okay.
How you
You
just
have
strike-
filed documents making commercial demands, demanding accountings,
Yes.
challenging the capitalization. No, you didn't do that, but challenging different things about who you are and who you would in equity
Yes.
minister to,
And for
those
me,
kinds of things. Ma'am, you understand those have no basis in Indiana criminal law.
okay.
You realize
But-
that?
But let me explain. Can I make a statement to you then? You said there's no basis in criminal
Go
law.
ahead. What's your statement?
Well, I also want to say something. And also I am a minister, and I want to read this on the record, okay? And it states that should a man prove himself to be living and not dead, nor lost of sea, his estate must be returned to him with mean profit. I am the living man that has a womb. I have accepted appointment of this office of executive. As such, this office gives notice of its accusations and findings. And now I have issued orders, okay? And in the scripture, the living and the spiritual man judgeth over all things, yet he shall be judged by no man. And that's 1 Corinthians chapter 2, verse 15. Like I said, I came here with clean hands. And I'm now the executive. My estate has no longer been abandoned. And I don't allow no more trespassing and interloping upon and administrating it. I discovered a lot of things along the way, putting me in this position.
Okay, ma'am. Clean hands is an equitable doctrine. You understand that? This is not a court of equity. If you were in a court of equity, you wouldn't even be given or afforded the right to a jury. I think it's appropriate for me at this time now to terminate the Faretta inquiry, deny your request to proceed pro se. I'll specifically find that the request is not a genuine attempt to present a legal defense, but a calculated strategy to obstruct and subvert the court's proceedings. The defendants utilizing rhetoric of what would typically be called a sovereign citizen movement,
No.
including raising nonsensical
No.
challenges
No,
and attempting to apply commercial law to criminal prosecution
No.
or equitable law.
no, that's not
Ma'am, you
true.
keep saying no, but you're talking over me and I don't appreciate it because I'm trying to rule. The right of self-representation is not a license to abuse the dignity of the courtroom or nor relevant rules of procedure and substantive law. Based on the defendant's filings and her statements in open court, court finds she's unwilling to comply with rules of procedure and intends to use self-representation solely for deliberate disruption of the proceedings. The request to proceed pro se is denied and appointed counsel will remain on the case. We're adjourned.
I will deny the request for an indigency hearing because I agree that you were represented at that time. Even without being represented, you reached an agreement, and the basis of Judge Mangram's order, which ordered you to jail and then suspended that order, is also based on your agreement, which you and Ms. Oren announced in open court before Judge Mangrum.
I object, Your Honor. I did not agree.
Mr. Gwynn, it's okay if you object, but wait to urge it until I am finished. You do not get permission to talk when I'm talking. I get to interrupt you. I get to interrupt Mr. Powers. That is the prerogative of my office. You, however, nor does Mr. Powers, however, have the right to interrupt me. And if you do it one more time, it's going to delay the process. And none of us wants that. So stop, please, interrupting me. It'll prolong our time together. Be patient. I'll let you say your piece, I promise. I'm just where I'm coming from so that you can react to what I'm saying.
Yes, Your Honor.
But I can't say it unless you give me an opportunity to do so. So for those reasons, which is what I'm trying to articulate, I do not believe you are entitled to yet another opportunity to attack collaterally the prior order, and the suspension and the now request to revoke it will proceed at this time. Now, I appreciate that Mr. Gwynn objects to that. His objection to that is noted. Now that we have completed the process of opening statements, we'll move to evidence. As I indicated earlier, Mr. Powers will present his evidence first, and then Mr. Gwynn will have an opportunity to present his evidence, at which time I will make a decision. Mr. Powers, you may call your first witness.
Your Honor, I will ask the court to recall the testimony of Ms. Warren, who's already testified when this case was recessed, that she's received no payments from Mr. Gwynn since January 2022.
I recall that testimony. You asked her one question. She answered it. That was the gist of the testimony, and then she was excused, and then you and Mr. Gwynn and I talked about reset dates and so forth. I recall it. What else?
I need to call myself as a witness on attorney's fees.
Raise your right hand. I'll swear you in. Do you solemnly swear or affirm under the penalty of perjury that the testimony you will give in this cause will be the truth, the whole truth, and nothing but the truth?
I do.
State your name.
My name is William Powers. I'm an attorney licensed to practice law in the state of Texas. I've been licensed since 1976. I've been board certified in family law since 1988. I'm familiar with the fees charged in Central Texas by attorneys of
with you on that day. Subsequently, she
were $1,937. And since that time, we have incurred attorney's fees, the other hearings that the court has recited on the docket in the total amount of $4,575.42.
Okay. And since July 6, 2022, you have incurred $4,575.42 in attorney's fees. Is that right?
Yes, ma'am. And those fees have those fees been paid by your client? They have not.
All right, go ahead.
I believe those fees were necessary and reasonable given the circumstances of this case. It's been very difficult to get Mr. Gwynn in front of a court. It's been very difficult to proceed forward in this case, and we've had since that July hearing. I can't, and by the way, we're including today's hearing as part of that.
No, it's not.
Oh, I'm sorry, we're not including today's hearing as part of that. So there would be another $550 for today's hour before the court. And based upon the dockets that you previously read in, I think the court can understand just how much time has had to be devoted to get Mr. Gwynn before the court today.
Thank you.
And I'll pass myself.
Mr. Gwynn, now it's your opportunity to ask Mr. Powers any questions regarding the attorney fees that he's testified to this morning. You may proceed.
Your Honor, we all wish to remain in voluntary compliance with the IRS.
I'm sorry, do you have any questions for Mr. Powers regarding his attorney's fees request?
Yes, I'd like to know if we all remain in voluntary compliance with the IRS. Doesn't Mr. Powers?
I will object to the relevance of the question.
I don't understand the question, first of all, but I also don't know why whether or not you or he are in compliance with the IRS is relevant to whether or not I should allow him or should award him his client attorney's fees for the work done on the case. So I'll sustain the relevance objection.
Because I'd like to know whose name goes on.
I'm just asking if you have any questions for him regarding the attorney's fees he's requesting today.
Whose name goes on the FinCEN 8300?
I don't know what that is either, and I don't know why it's related to whether or not he's going to get some attorney's fees. So if you have questions about whether or not he should be awarded some attorney's fees, you may ask him that question. I'm going to assume you don't want me to give him any attorney's fees, so I appreciate the position.
No, I don't. And
Okay.
Here's another. Trezevant versus Tampa is billable at $3,000 per minute for renting my natural son, as well as time and commodity for total.
Okay. Mr. Gwynn?
My fees.
Mr. Gwynn? Mr. Gwynn?
Fees, and for
Mr.
renting,
Gwynn?
taking my son from me and
Mr.
making
Gwynn? Mr. Gwynn, can you hear me?
Yes, ma'am.
Okay. I'm going to ask you one more time. You will, let me tell you a couple of things first. One, you will be allowed to provide your own testimony when it's your turn. So if you want to tell me your side of the story, make whatever request you want to make. You may do that when it's your turn to testify. But right now, it's not your turn to testify. Right now, all we're doing in this very limited part of our proceeding is giving you the opportunity to ask Mr. Powers questions about his request for attorney's fees. That's it. And when we're done with that, we'll move on. But right now, we're just limiting your questions to his request for attorney's fees only, nothing else. So if you have a question about that, please ask that question.
Okay, I do have a question about that because if he's wanting to bill me, is he gonna get my bill too? I have a bill as well.
Okay, that is not a question about his attorney's fees. That's a question about your request. That's not what we're doing right now. So if you have a question about his request, what is your question?
The IRS handles issues of billing, and so I just want to know: do I put his name on the IRS documents that I submit for his billing?
That is not a question related to his request for attorney's fees. He wants me to order you to pay him. That's the only thing on the table right now. Do you have a question for him about that?
I do not consent to.
I appreciate that you want me not to give it to him. I get that. The question is, do you have any questions for him about it?
Ma'am, I just want to make sure we all remain in compliance with the IRS, and I just
Well, I'm going to assume by your statement that you don't have a question for him about his attorney's fees. I, however, do. So I will ask it at this time, and then I'll give you a chance to follow up if you can think of a question. Mr. Powers, with regard to the order from Judge Harger awarding the $1,937, has that amount been paid?
No.
Okay. All right. And was
So,
there, excuse me, no, I just have some very specific and limited questions for both of you, and I would appreciate if you both just answer the specific questions I'm asking. Was there a date certain in the Harger order on which Mr. Gwynn was ordered to remit to you that $1,937 amount?
Yeah.
I believe so, Your Honor. We're going to pull up the order for the court. We'll ask you to take judicial notice of your court file.
I just want to know when he was ordered to pay, by what date he was ordered to pay it.
May the 6th, Your Honor.
Okay, I'm confused because I thought you told me it was through July 6th.
It was through April 6th.
I'm sorry. I We've been so many hearings, I get a little confused. This was through April the 7th.
Not July.
Yes, ma'am, that's right.
So in April, Judge Harger ordered this $1,900 amount, roughly. Is that right?
May 6th. Yes, ma'am.
Okay, very good. That's my question. Now, I've asked a couple questions, Mr. Gwynn, so I'm going to give you one more opportunity to ask a relevant question about the issue of attorney's fees that Mr. Powers is requesting, if you have one, about that. And if you do, you may ask it now.
Your Honor, IRS handles those kinds of issues, but, you know, earlier, Mr. Powers said that there was a $6,000. If you note in the beginning of this hearing, he said there was a $6,000 fee that he had, and you know, it's changing, and it constantly changes. And this is what Mr. Powers just constantly has been burying me for years.
Okay, so that's not a question, it's a statement. You will be allowed to make statements both in closing argument and when it's your turn to testify. I simply want to know if you have a question that you need to answer. What is the question you want to ask him about his request for attorney's fees as testified to this morning?
I definitely want a detail. I would like a accounting of it all.
Ask him a question, Mr. Gwynn. Take a step. Ask him a question.
I would like to request a detailed accounting of everything that he claims that I owe, and I would also like proof of this detailed accounting of what I owe, and I will take it under consideration. But I need to see proof. Where does he get these numbers from? Because they constantly grow, and it's like the $125,000 that he claims that I owe. Where's the proof of that? How do I owe that much, and why? Know why? So I'd like a detailed accounting, and I will take it under full consideration.
Do you have any other questions that you wish to ask Mr. Powers?
And my other question is, when will I get that?
Any other question you want to ask him?
If he can just answer that for us.
He's not required to give you what you've asked for today, and that is beyond the scope of what you're allowed to ask him questions about today with regard to the $125,000. I will construe your question about the accounting of his attorney's fees, and I will ask Mr. Powers to answer a question about whether or not he has detailed records with regard to the attorney's fees he's requesting today. Mr. Powers, what is your answer to that question?
And Your Honor, I accept that.
Hang on a minute. Let's let him answer that question first, and then you can ask another one. Mr. Powers?
Your Honor, I keep contemporaneous billing on a tenth by tenths of an hour, and so there is in fact detailed billing of that. I will show the court petitioner's number 23.
You have permission to share your screen.
And this breaks out for the court my billable time and the billable time of my paralegal. We will offer 23, and I will submit that.
So let me just clarify. Is 23 is your billable hour invoice records of your attorney's fees? Is that what you're telling me?
Yes, ma'am.
Is it an accurate reflection of the fees that you're requesting today and other fees listed in the exhibit?
Yes, ma'am.
Mr. Gwynn, do you have any objection to the admission into evidence of petitioner's exhibit number 23?
I would like to have it sent to me so I can consider it fully.
Yes, but do you have any objection to me looking at it, having it come into evidence?
Yes, I do, because you're not supposed to.
What is your legal objection to why I should not be able to look at his attorney's fees affidavit or request?
I don't know if you can practice law from the bench.
I don't intend to, and nor do I believe that's what I'm doing. I'm asking you to tell me what your legal objection is to the admission of this piece of evidence. What's your objection? Legal objection you have to it. Is it hearsay? No. Is it something else? That's
you can't. It hasn't been put under consideration, and you can't practice law from the bench.
Okay, I don't understand your answer to my question. My question to you, let me summarize. Let me summarize. Mr. Powers is offering this document regarding his attorney's fees that you requested. He's offering that piece of evidence into this hearing as petitioner's exhibit number 23. My question to you is whether or not you have an objection to petitioner's exhibit number 3. And if you do, what is the nature of your legal objection to the introduction of this document?
Yes, I do, and I haven't seen it. And I need to see it and inspect it, and then take it under full consideration. Once I do that,
okay, that objection is overruled. Petitioner's exhibit number 23 is admitted. Do you have any other questions you wish to ask Mr. Powers?
I would like to name whose name do I put on the financing?
That is not a question, Mr. Gwynn. You've asked that several times. That is not a question about his request for attorney's fees. So if you have any questions for him about his request for attorney's fees, I will let you ask it. Otherwise, we will move on.
Yeah, I'll accept them after after I review them and then give full consideration on them.
Okay, that is not a question for him, so we will move on.
Petitioner's number 21, Your Honor.
Which is what?
Petitioner, I'm going to share it with the court. This is that Mr. Gwynn sent to my portal for payment of $5,000 dated the October 18th is when it was the payment due. The payment date on this document, and
this is since the October 6th hearing in front of me, in advance of the October 21st hearing.
Yes, ma'am.
Okay.
This is one of the reasons we kicked the case down the road. Was waiting for this to clear, and you'll see that it in fact did not clear.
All right, Mr. Gwynn, Mr. Powers has offered the transaction receipt for the payments that you indicated you were going to make, and he's offering this as evidence that those didn't clear the bank. You've indicated that they didn't clear the bank either, so I don't think they're in dispute, but I'll ask if you have any legal objection to the introduction of the documents, and if so, what is your legal objection?
Well, offer of payment is payment, and electronic fund transfer was successful. I checked with Telecheck, and it's confirmed. There's been no refunds.
Do you have a legal objection to the introduction of the document into evidence? You can dispute it if you want to when you testify. That's fine. But the question is there a legal reason why I shouldn't accept the document in evidence?
Yes, I would like to inspect it first.
All right. Well, he's showing it to us on the screen, and so that's what he's required to do. I understand, Mr. Gwynn, I understand that you have objected to it. The objection is overruled and the document is admitted. Mr. Powers, is there any other evidence you wish to offer at this time? Petitioners 21 and petitioners 23 are admitted. Anything else?
Yes, if you want to.
I think I'm going to rest. I'm going to rest at this point, Your Honor.
All right, Mr. Gwynn, Mr. Powers has rested his case in chief. It's now your opportunity to put on your case in chief, and you may do that by offering documents into evidence, by calling witnesses. What is your pleasure with regard to how you wish to proceed next? You want to call a witness or offer some documents or call yourself as a witness?
The first thing I'd like to do is ask who gets my bill. Who gets the bill for renting my son?
So that is neither of the options that you have. That doesn't fall into any of those categories. So you can do a couple of things, right? You can call a witness. Do you have any other witnesses you wish to call?
I don't, but...
Okay, hold on. That's option one. Option two is that you might introduce some documents, very much like the process we just went through with Mr. Powers' 2 documents. Do you today have any documents you wish to offer into evidence today?
I do, ma'am, and I put them in evidence. I uploaded them into the...
Okay, well, tell me the number of the exhibit that you want to offer, and then we'll take a look at them, and then we'll see if there's any objection to them, and we'll proceed from there. And so what number exhibit did you upload that you want me to consider as evidence? And do you wish to testify about those documents, by the way?
Yes, ma'am, because I put
Hey, let me go ahead and swear you in. If you'll raise your right hand, I'll swear you in. Do you solemnly swear or affirm under the penalty of perjury that the testimony you will give in this cause will be the truth, the whole truth, and nothing but the truth?
I do, Your Honor.
Okay. All right, Mr. Gwynn, if you could just state your name for the record, please.
Jonathan Daniel Gwynn.
All right, Mr. Gwynn, tell me the exhibit numbers. If you could just briefly describe what those exhibits are. We'll go through those one at a time, please.
So, Your Honor, the first one is a filed and recorded promissory note. I'm not sure.
What's the exhibit number?
Ma'am, I do not know the exhibit number. I'd have to get off my. And,
well, you said you uploaded them. Did you upload in some sort of order?
I uploaded. So I have 3 documents that I want to submit. The first one is the promissory note. That's the last one that I submitted.
Okay, I'll tell you what. Let's do this. Since there are only 3 of them, it won't be that complicated, and we can renumber them for you if we need to. Let's call the promissory note respondent's exhibit number 1. Okay.
Okay.
And that'll be the promissory note. What is respondent's exhibit number 2? What's the second document?
It's a contempt of hearing notice.
Respondent's exhibit number 2 is a contempt hearing notice. Okay. And what's your third document?
One second, Your Honor. No, there's an allonge to the promissory note, but the other one is my Turner and Rogers request.
I don't know what you mean by Turner and Rogers request. So tell me.
It's an affidavit for.
Hold on.
Affidavit in support of sua sponte motion pursuant to 14.
Okay. That's.
I'm sorry, Mr. Gwynn, the last part of what you said cut out. You said affidavit in support of sua sponte motion pursuant to, and then I didn't hear what you said.
CFR 303.6. And then on my promissory note
wait, hang on. Are there other documents other than those 3?
No, yes, ma'am, because on my promissory note.
Hold on. Is there another document that we could mark as respondent's exhibit number 4? And if so, what is the title of that document? If what you're telling me is that exhibit number 1 contains a lot of other things with it, that's all part of exhibit number 1 and will be considered all together. I'm asking, you told me you had 3 documents. We've marked those 1, 2, and 3. I'm just trying to figure out if there's a 4th one, or if you now want to stop talking about other documents and just tell me about the 3 that I'm trying to understand.
Okay, so the 3 on the promissory note, there's an allonge to the promissory note, Your Honor.
Is it part of what you uploaded into the box?
It
is. Exhibit number 1 with the promissory note?
Yes, it is.
I'm going to consider all of that number 1. And I'm going to consider the contempt hearing notice number 2. And I'm going to consider the affidavit in support of the sua sponte motion. I'm going to consider that number 3.
Okay.
All right. So, Mr. Powers, any objections to respondents' exhibits 1, 2, or 3?
I wasn't, Your Honor. I also would like to submit tax forms 8300, tax forms.
Wait. I need to have exhibit numbers attached to these documents. So I need you to tell me the exhibit number. You told me you only had 3, and that's why I stopped.
Sorry,
it's okay. What's number 4?
Tax form number 4 is my. I already gave you number 4.
No. Just tell me what the document is that you want marked as exhibit number 4. I do not have a number 4 yet.
80. Or the 8300 tax form.
Tax form 8300. Is that what it is? That we'll call respondent's exhibit number 4.
Yes, and then number 5 is 4506A tax form, and number 6 is a W4, and number 7 is a 1099. And the number 8 is a 14309 tax form. And number 9 is a 3949A. I've already given you my allonge. And then a 1309.
Wait. Number 9 is a What?
Seriously. 3949A tax form.
Okay, and what's number 10?
13909 tax form.
Okay,
And then a 211,
is that number 11?
11, and then the 12 is
211 wait, what is 211? What is that?
tax form, 211. And then
All right.
the tax form, and then the tax form 911.
Is that number 12?
Yes, ma'am.
Oh.
And I need a copy of their W7.
No. Your introduction of documents that you want considered in evidence.
Yes, ma'am. I'd like to offer their forms, W7, W8, W9, and FR 2046.
I don't know what you mean when you say you want to offer their forms. Have you uploaded documents into the box folder as required by our rules? Documents that you want to offer in your box folder. Do you have those available today?
Yes, I do.
What is the number? Next number would be 13. What is number 13 that you want to offer?
I would like to offer W7. 14 is a W8. 15 is a W9. 16 is a F, as in Frank, R 2046.
Okay.
And
Any other documents you want to offer today?
No, ma'am. That'll do it.
All right. Those are 16 documents. I might need a little more information about some of them. Tell me about the tax form 8300, which is marked as exhibit number that document, and why is it relevant to this proceeding?
I'm sorry, Your Honor, I wasn't done. I had one more, and it's called a 56F. I'm so sorry to do that to you.
No problem. 56F will be number 17. What is a tax form 8300, and why is it relevant to these proceedings?
FinCEN, and I have to report the money. It's a FinCEN. I have to report the money.
What does it have to do with whether or not you are in compliance with your child support obligation?
Because I have to be in compliance with the IRS, Your Honor. We all do.
Okay, all right. And is that the kind of the same nature of these documents, like say, for example, the numbers 8, 9, 10, 11, 12, 13, 14, 15, 16, and 17 that you also said were tax forms? Are those related in some way to some obligation you have to the IRS?
Yes, Your Honor, and it's also identity theft for my Social Security number.
Sorry, hang on. You answered my question when you said yes. Number 6, Respondent's Exhibit number 6, which is a W-4. Whose W-4 is that? Yours? I couldn't hear you.
There's, Your Honor.
W-4, Exhibit number 6, the W-4 form, that's, whose name is on the W-4?
Powers.
Okay. All right. I think I have a sense. Thank you. That's really helpful. Oh, another question about your exhibit number 2. What hearing notice, contempt hearing notice is that?
That is for Turner Rogers. No, that is let me get that. Let me pull that up.
You told me that number 1 was a promissory note. You told me number 2 is a contempt hearing notice. I want to know what hearing is related to that notice. Exhibit number 2.
Okay, so that is a judicial notice of Article 1, Section 10, Clause 1 of the United States Constitution, which states...
Wait, hang on. Stop. I'm asking if there is... You said it was a hearing notice. I'm simply asking what hearing date is mentioned in that notice and in what court? That's my question.
I've requested a hearing for it, Your Honor, but it's to because no state shall make anything but gold or silver coin a tender in payment of debts or law impairing the obligation of contracts. This state prosecutors...
Mr. Gwynn, stop.
To establish...
Stop. Is the hearing notice that you marked as exhibit number 2 filed in this cause number in Travis County, Texas? Yes.
Ma'am, it is filed now for the 3rd time. I filed
in this my question is it a hearing notice in which there is a hearing scheduled in this cause number in Travis County, Texas? Does the notice tell you or Ms. Oren to be present at a hearing in Travis County, yes or no?
Absolutely, Your Honor. It's been stamped And it's just
Okay, all right, very good. And if it tells somebody to be at a court hearing in Travis County, can you
wife's
tell
attorney.
me the date of that?
it was never set, Your Honor. And I put it in court now over 6 months ago.
All
It's-
right, okay.
And I have
That's helpful. Stop. That's helpful. I'm just trying to get a sense of what hearing date it's a reference to. Thank you. All right, Mr. Powers, your opportunity now to tell me if you have any objection to any of the exhibits that have been offered. Let's start with the first three. Any objection to one?
Your Honor, one more thing is, all this is for the Foreign Agency Registration Act is what these documents are for.
Thank you, Mr. Gwynn. It's now Mr. Powers' opportunity to answer my question. Any objection to exhibit number one?
Yes, ma'am, relevance.
What objection do you have to two
Relevance.
and to three?
Relevance. I can give you basically.
I'm breaking them down in kind of by sort of category. So
Yes, ma'am.
those are a little bit different from the tax form. So let's now move to the tax forms, which, as I understand it, relate to the offer of exhibits 4 through 17. What objection?
Object to exhibits 4 through 17 on the basis of relevance.
Okay. All right. Mr. Gwynn, the relevance objection suggests that none of these documents are related to the matter before the court today. I'll give you very briefly an opportunity to why they might be relevant to whether or not the suspension of commitment should be given effect today.
My
Documents have to do with this case.
My IRS agent would like to keep all of us in compliance, and I need all those documents. Anything that I spend, put out, or am billed for, I need to have for my IRS agent.
Okay. All right. Very good. That's very helpful. 17, but please know, Mr. Gwynn, that for purposes of the appellate record, all exhibits that are offered, whether admitted or not, will become part of the case record and available for the appellate court review. So we'll continue to keep them in our records. They'll just not be considered for purposes of the hearing today. Now, Mr. Gwynn, your opportunity next is for you to offer some additional testimony. And because you're representing yourself, it would be silly to ask you to ask yourself a question and then answer it. So I will let you testify in what we call the narrative form. However, if you hear me interrupt you, or if you hear Mr. Powers interrupt by saying the word objection, then I need you to stop your testimony until I've had a chance to deal with the objection that he raises. Or if I need to interrupt you for various reasons, I will let you know. But so now, though, it's your opportunity to tell me whatever evidence you want to offer by way of testimony with regard to just the matter before the court, which is whether or not your suspension of the jail order that Judge Mangrum entered should be given effect or not, and should I send you to jail or not, and whether or not I should suspend that order further by ordering that you can stay out of jail by paying some amount of money. It could be some amount you pick, or some amount that, if you wish to react to the number that Mr. Powers gave, you can do that as well. I'm ready now for your testimony just on those relevant matters pertaining to the hearing today and none other.
Okay. Thank you, Your Honor. Your Honor, first off, I object to representing myself as a person. I'm actually representing the corporate Jonathan Daniel Gwynn name is who I'm representing, not me as a person. I'm representing the all caps name.
You cannot represent it as corporations by Texas law, must be represented by licensed attorneys. You've told me you're not a licensed attorney, so you're not allowed to represent anybody other than yourself, and you certainly may not be allowed to represent a corporate entity. We'll move on.
I do not represent myself, Your Honor. I do not represent.
Well, let's move on. Let's pass. I understand. Let's move on. What else? I'm asking you to provide whatever additional testimony you wish to provide at this time.
Your Honor, I would like to know if you're standing on your oath today.
I would like to know if you have any additional testimony you wish to provide, because you're on the witness stand. It's your opportunity to give testimony. It is not your opportunity to ask questions. This is your opportunity to tell me your side of the story. And I want to hear it. So tell me your side of the story.
I just want to know if you're standing on your oath today, Your Honor. That's all.
I am not going to respond to questions because it would be inappropriate for me to do so in that way, at least to that question. I want to know if you have any additional testimony. If you do, I want to hear it. If you don't, we will move on.
I'm sorry, Your Honor. I do have other questions, but I just need to know if you're standing on your oath today. That's all I'm asking.
Mr. Gwynn, you will pass yourself as a witness unless in the next 30 seconds you provide testimony. If you do not provide testimony in the next 30 seconds, I will consider that you have no testimony on this matter to offer. So your choice, sir, provide testimony since you're now on the witness stand, or stand down from the witness stand. Your choice. You have testimony to provide or you don't. If you do, you need to give it to me now.
Okay, Your Honor, I just asked a question. I accept that you're not standing on your oath today, I guess. I don't know what to say because I just wanted to know.
All right, Mr. Powers, do you have any questions for Mr. Gwynn? Because he has passed himself as a witness by virtue of the fact that he has violated my direct order to provide testimony since he's been sworn in and is now providing testimony as a witness. You may ask him any questions if you like.
No, ma'am. I have no questions for Mr.
That will conclude the evidence portion of our proceeding this morning. Mr. Powers, you may make a brief closing argument.
I believe the record is abundantly clear. Mr. Gwynn appeared in court through counsel. He agreed to the imposition of the sentence we're asking you to.
I did not agree. It's an objection.
He agreed on the record.
I did not agree.
Excuse me, Mr. Gwynn, I have noted several.
You did effing too. You agreed to have it in writing. I mean, it doesn't really matter. Nobody cares. But how do you say that with a straight face?
Times that Judge Mangram's docket notation indicates that you did in fact agree. It's okay if you disagree with that. You can tell me about your disagreement to that when it is your turn to make your closing argument. Right now, it's Mr. Powers' turn to make his closing argument. I ask you, please, to be patient until it is your turn to speak again. Mr. Powers, you may proceed.
So it's abundantly clear that he was ordered to comply with a payment schedule. It is abundantly clear that he has failed to comply with the payment schedule. What I think is particularly appalling is that Mr. Gwynn submitted false documents that were intended to represent that payments were made when they in fact were not. This has been a very difficult case. Mr. Gwynn has historically projected gobbledygook legalistic arguments which have no merit and which are in fact dilatory, time-consuming, and costly for my client to respond to. Accordingly, it's time that Mr. Gwynn suffered the consequences of his failure to comply with the court's order.
Pretty cool.
And we're asking that the relief we requested at the beginning of the hearing be imposed upon Mr. Gwynn at this time.
All right. Thank you, Mr. Powers. Mr. Gwynn, it's now your opportunity to make your closing argument that might be relevant to the issues before the court this morning. If you wish to do so, you may do so. Let me warn you, sir, if you do not stick to the rules and make a closing argument that is relevant to the proceedings, I will interrupt you and then I'll issue my order. So please, just please make a relevant argument to the matters before the court this morning and none other. You may proceed.
Your Honor, I do not consent to jail. I do not consent to jail. I do not consent to jail. Consent to a judge not answering about on oath. I do not consent to the judge standing not standing. I do not consent to not being in compliance with the IRS. I do not consent to not being in compliance with the IRS. I do not consent to further hearings. I do not consent to further hearings. I do not consent to the renting of my son. I do not consent to the renting of my son. I do not consent renting of my son. I will say that again because that is my blood-born son, and they have stolen him from me, and that's unconstitutional. And I also do not consent representing myself. I do not consent to representing myself. Do not consent to representing myself, Your Honor. And I have filed paperwork that is constitutional paperwork that Mr. Powers is calling Google Goggle, whatever, GOP. And there is judicial stamps on my paperwork over the past 12 months that I have filed over and over again, and they just get ignored and completely ignored. And they are on the record, they are on file, and they completely get ignored. And I use
I can't hear you, Mr.
I want to stay of court pending. I want to stay of court pending a United States tax court.
Anything else by way of closing argument, sir?
I want to stay of court pending the United States tax court.
Anything else by way of closing argument that's relevant to the issues?
I want to stay of court pending United States
Yes, you've
tax.
said that 3 times, sir. Is there anything else?
I just do not consent to go to jail, Your Honor. I've already shown you this, and I want to say it one more time because, you know, I know you turned down my Turner hearing. I have a promissory note. Promissory note is constitutional. It's in law. Even my IRS agent said I could use it. And I've been wrongfully accused here over years. I haven't seen my son since he was 4 years old. I raised him daily. And Mr. Powers managed to take him away from me and caused so much hardship in my life over this. And I have been wrongfully accused of being a bad father when I'm a great father. And you can see it on my internet. You can see it on my social media, how great a father I am to my current 10-year-old. And I wasn't able to father my child because this man has robbed me of that. This court has robbed me of that. And it is completely unconstitutional that I have done this. And full constitutional principles and protection that was articulated by the U.S. Supreme Court, Turner, you know, and I incorporate by reference all orders of this courts are fully submitted pursuant to Judicial Notice Section 201. The rules require a scalpel, not a butcher knife. And this court ordinarily must apply it to each segment of an affidavit. And none of my affidavits have been responded to, not one. And I have submitted probably over 50 affidavits, and they've all been stamped by the judicial clerk. And not one has been responded to by a judge, Your Honor. Not one. And that is unlawful and unconstitutional. And now I'm asking a judge, Your Honor, with all due respect, and I'm here in front of a judge asking if you're standing on your oath, and I can't even get an answer there.
All right.
And I accept.
Thank you, Mr. Gwynn. Is there anything else?
And I accept that and default of this hearing.
Anything else?
Brought upon the court, by the court, Your Honor.
Okay. Anything else?
I can go on and on, Your Honor, but I just want to get rid of this. And
okay. All right. Thank you, Mr. Gwynn. Normally, I would allow the movement to have the last word because he gets to rebut, but I don't think that's necessary here, Mr. Powers, because I think you've made your position clear on behalf of your client with regard to the relief you request. The relief is granted. Mr. Gwynn, what I want to remind you about is a couple of things. One, when you were here the first time I met you in October, you told me that you were turning your life around and that you were going to do the right thing and pay the amount of money that you owed. And you told me that because you were in that rehab facility, that you needed time to get out of there and get some money together. And I believed you, and I gave you that opportunity. But you didn't keep your end of the bargain in that regard. You showed up later that same morning behind the wheel of a vehicle. So you may not own one, but you clearly have access to one because you were driving a vehicle on Zoom when I asked you to pull over, right? Because
on the property.
excuse me, I also pointed out that you had changed your clothes. You were nicely dressed at the first part of our hearing. You were more casually dressed later in the day when you were driving. And I questioned whether or not you were really at a rehab facility. But
that is not the issue here.
Excuse me, Mr. Gwynn, it's my turn. And but my point there is that I believed you nonetheless. I believed that you wanted time. I believed that you needed time. I believed that you were going to do your best, having come out of that rehab facility that you were excited about being in and graduating from. And I believe that if given an opportunity, you would do the right thing and come up with the money you said you were going to come up with. And excuse me, sir, I am not done.
I'm asking for forgiveness because
I'm asking you to just be quiet while I finish my statement. I believed you on October 6th, and I gave you a chance to do the right thing, and you didn't do it. And then on October 21st, I gave you another chance because on that day you made me another promise, and yet you haven't kept that one either. On October 21st, you gave me a promise. You said, I'm going to pay these people this $5,000, and I'm going to pay them another $20. Mr. Gwynn, it's not your turn. And I'm going to give some more money later, and I'm going to make good on my promise, Judge. So please postpone this hearing one more time.
I did with a promissory note.
Make a promise to you that I'm going to keep. So October 6th, you made me a promise you didn't keep. October 21st, you made me a promise you didn't keep. And now here on November 9th,
Your Honor, I paid it.
Mr. Gwynn, if you don't stop talking, I'm going to ask my staff to mute your microphone. It is not your turn. I gave you an opportunity to tell me something relevant about this hearing, and you did, and you talked, and I kept asking you if there was anything else. And then when you stopped, I started. It is now your opportunity to be as respectful to me as I have been to you. So I would beg you, please stop talking when I'm talking. So to summarize, I gave you a chance on October 6th. You gave me a promise you didn't keep. I gave you another chance on October 21st. You made me yet another promise, which you did not keep. Not only did you not keep the promise, the funds you pledged turned out to be bogus, and they didn't clear the bank. So that's problematic from my perspective, that you've been given chance after chance. You made promise after promise. You squandered the chances, and you broke the promises. I think we're at the end of our ability to be gracious to you anymore. I think now you have to show some grace and pay your debt. And you will begin by paying, or you will go to jail. And so the order is as follows. The motion is granted. Mr. Powers will be directed to prepare an order today. I want it today so that it can be signed and given effect today and served on all the proper parties and sent to the proper authorities to be effectuated today. The order will reflect not only that the motion is granted, but that Mr. Gwynn is to be remanded to the Travis County Jail. He'll be told in that order where to report. I would imagine it would be downtown at the booking station here that is adjacent to the Travis County Courthouse. It's the Blackwell Thurman Criminal Justice Building. Mr. Gwynn, you will be, and so since I do not want you to report and infect others, and I want you to have an opportunity to heal and get better, I will require that your report date be at 10 a.m. on November 15th instead of today, because I want you to have an opportunity to get better. So you will be required to report to the Travis County Jail at 10 a.m. on November, earlier, but no later than 10 a.m. on November 15th. If you have paid before that date, by the 14th, if you have paid by the 14th of November, the sum of $7,500, you will not have to report. That will not end your obligation. That just means you don't have to report, and the suspended commitment will remain in effect. The review hearings, and you will still be subject to going to jail if you don't further comply. But you will prevent on the 14th if you have paid the sum of $7,500, not pledged it, not written a check that doesn't clear, but actually remitted funds that clear the bank or cash, one or the other, that's valid negotiable tender. And if you do that by the 14th, you don't have to report on the 15th. If you don't do that by close of business on the 14th, you must report on the 15th. Mr. Powers will circulate that order, and get it to me today. And that will conclude our business this morning. Apologies to those on the docket who I told we'd only be an hour, because clearly we've gone more than that. Gentlemen, we are adjourned. Take care. Goodbye.
Thank you, Your Honor.
State of Kansas versus Isaiah Curvin, 24 TR 17. Would counsel state their appearances, please?
I'm here, Your Honor.
May it please the court, the state appears by Jill Gillette, County Attorney.
And you're Isaiah Curvin, correct?
Correct. Yes, I'm here.
Thank you. All right, Mr. Curvin, there was an earlier date where you failed to appear. A warrant was issued. You were picked up on that. You posted bond. The court order was for you to appear at the sheriff's office, which you've done. We'll move on. Today was set for a pretrial. At an earlier hearing, you had pled not guilty, or plea of not guilty had been entered on your behalf. I have reviewed the file. There was a document entitled Notice of Special Appearance by Affidavit. Mr. Curvin, did you file that?
Yes, sir.
All right. I have reviewed that. Ms. Gillette, do you wish to make a comment on it before I rule?
I do not, Your Honor.
Very well. Mr. Curvin, is there any brief statement that you want to make in support of your motion?
Oh, well, I want to ask a couple of questions before I get on to anything.
You can start.
Okay. Yes, I want to know what I'm going to be tried, jurisdiction I'm going to be tried under. Is it going to be civil or is it criminal?
I think we went through this before, and you're charged in the state of Kansas, and this is the Elk County District Court.
Okay.
So you are charged with operating a motor vehicle without a valid license. That is a Class B non-person misdemeanor, punishable up to 6 months in the county jail and a fine not to exceed $1,000.
Yes, I still don't understand it. I don't understand. Is that a criminal or is that a civil? Is that a criminal?
Well, Mr. Curvin, I've seen these motions before. I think you well understand where you're charged and what you're charged with. So let's not fool each other here or play games, please.
No, I'm not playing any games. This so I can properly defend myself because criminal and the civil, there are two different ways of doing things. In order to properly defend myself, I'll have to know which one am I going to be tried against.
You are charged in a traffic matter that is treated as a criminal. You would have the right, all the same rights that I mentioned earlier when I went through the rights. You would have the right to a trial by jury or court if you make the timely and appropriate motion in writing for the jury. Otherwise, it would be a bench trial. The duty would be on the state to prove you guilty beyond a reasonable doubt.
Okay. And you said it would be a criminal matter, you said?
I mentioned that already, how it's treated. It's a traffic case.
Okay, that's what I was asking, just to verify. So if it's criminal, if it's under the criminal, then it has the court grants this under Article 6 to jurisdiction under the criminal matter.
Okay, Mr. Curvin, I have read through your motion. I disagree with your assertions of the law. Your motion is denied. We will set this matter for trial. Are you going to be representing yourself, or are you going to hire an attorney?
Well, before I go to trial, I have to know what's some questions I really have to have answered before I can enter anything, so I can properly defend myself.
I've answered the questions that are appropriate. Now, your motion and the things that you have in there, again, they're not accurate statements of law in regards to these type of proceedings. Your motion is denied. So we're going to set this matter for trial. Okay. I need to know if you are going to be represented yourself, or are you going to be hiring an attorney?
Can I ask what is the reason for my motion to be denied?
I've already ruled on it. It's not applicable law to this case. So, and your assertions of what the law is are inaccurate to a large degree. So
yeah, that's
I'm going to go through line by line to do that.
No, I'm just trying to see to understand which ones you're referring to, so I can understand what was wrong, so I can know which one you're stating that's inaccurate, so I can have an understanding.
All right. So my question is, are you going to represent yourself, or are you going to hire an attorney?
Well, before we get to that, I have to know how to defend myself.
All right. We're going through this cycle here, and I'm not going to play the game.
No, I'm not.
Sir, be quiet. You're here for a pretrial where you're not being responsive to my questions. If you want to have an attorney, you have the right to have an attorney. If you wish to be represented by counsel and if there's any risk to jail, typically there are times where there is a jail sentence that gets attached to this charge. You can apply to the court. If you meet the criteria, I'd appoint an attorney to represent you. Like I told the gentleman before you, that doesn't mean that you're going to be free. You also have a right to represent yourself. Those are the choices that you have. So you can hire an attorney, you can apply for one, or you can represent yourself. It's one of those three. Which one are you going to do?
Well, from my understanding, once jurisdiction is challenged, it's on to the plaintiff to prove the jurisdiction on the record.
That's at a trial. One of the issues that the state would have the burden of proving is that this occurred in this jurisdiction, which is Elk County, Kansas. That's a question of fact for the trier of fact.
But isn't a jurisdiction could be challenged at any time?
All right. I'm going to find that you're waiving your right to an attorney. I have requested you to answer that question numerous times. I'm going to set this. Stop interrupting. I'm going to set this matter for trial.
Before you do that, I still have I haven't answered my question. I'm trying to understand to come to a conclusion to see how I'm going to handle my case.
All right.
I'm still
you have been asking questions that are not relevant to these proceedings, and I think you're aware of that. I've seen these motions before. I've seen the people try to do exactly what you're trying to do now, where you're not going to piecemeal this out. I've answered your questions, and I'm setting this matter for trial. That would be in person at the Elk County Courthouse. Sarah, we need to have a 2-hour, stop talking. We need to have a 2-hour setting.
Can you correctly reflect that this court plans to bring a case against me, which it does not, will not let me know what I'm going to be facing against? Because I'm just asking the question to get a proper understanding what's going against me. Because I'm not understanding the jurisdiction of this, which jurisdiction I'm going to be tried under. That's all I'm asking, just to get some type of clarification. That's it. I'm not playing the games. This is a serious matter. This is a court date. I came all this way to understand, to see how it's going, to properly defend myself. I'm not trying to waste your time.
Not going to argue with you about.
No, I'm not here to argue neither, Arne. I'm listening to what you're saying. I don't want to. I heard everything. It just I want to understand what's going on, and if it's how does the trial work if I don't?
You need to be quiet now, Sarah.
I have one question.
Sarah, no, Mr. Kervin, I told you need to be quiet now. Sarah, do you have a date for trial, please?
I have a question. If I don't want to do a trial, what's the other option?
Mr. Kervin, I'm waiting for the clerk to give us a court date, please.
Yeah, that's
nothing further.
I'm asking you need to, because
Mr. Kervin, if I have to tell you one more time, you need to be quiet. I'm going to find you in contempt.
Yes, Judge. We can do the morning of October 28th at 10 a.m.
October 28th at 10?
Yes, sir.
Okay. Our trial will be October the 28th at 10 a.m. That will be at the Elk County Elk County Courthouse. Mr. Kervin, as I've explained to you, you have the right to be represented by an attorney. That is, if you wish to ask them questions, obviously that's appropriate to do. If you're going to represent yourself, we're going to be going with what the rules are here in Kansas, not something that you've read online or in line with what you filed. So if I strongly represent or indicate that people are better off being represented by counsel, but that's your choice. But you understand what the penalties, potential penalties are. And if you're representing yourself, you're going to be held to the same standard as an attorney in regards to, being responsive and how you conduct yourself and how you present your case.
Well, I was asking about my fines. If I wanted to not do the trial thing, how was a fine, or does it have to be set for a trial in order? Like, that's what I'm asking.
All right. If you're wanting to plead guilty, you can. If you want to plead no contest, where you're not pleading guilty, where you're not admitting to it, but you're also not challenging what the state has done, you have the right to do that as well.
Yeah, that's why I was saying I wasn't challenged. I was just trying to understand. So how much is the fees or whatever once that's settled, would that take care of everything? And I'll need to know like the amounts for whatever it is.
Well, I have told you what the maximum penalties are. I don't negotiate with people. I don't tell them what the sentence is in advance. I'm required to tell people what the maximum penalties are.
Okay, so you said the penalty was jail time, but you didn't say the cost.
I said that I said that on a Class B misdemeanor, which this is, the punishment is up to 6 months in the county jail and a fine not to exceed $1,000. Court costs on this type of case are $108. There can be other things that are assessed as well. If a person was taken into custody, generally there's a processing fee of $45. Additionally, if somebody is found guilty, if they're placed on probation, there's a fee that goes along with that. There's various things that occur with that. But as far as the penalty section, I've advised you what the maximum penalties are.
Okay, so for the fees will be like you said like $1,000 and then about 40, so like about almost
I said that the maximum penalty is 6 months in the county jail and a fine not to exceed $1,000.
Okay, so do you have a number for me so I can see if I'm able to pay to see how much I would if I can even...
Okay, Mr. Curvin, what you're doing is asking me to give the sentence before you pled guilty. We don't do that. I've explained that.
If I do the no contents is what so I'm not arguing with you, I'm just if you said no contents is not an argument. So if I do no contents, what am I looking towards?
No contest. It's the same penalty. A no contest, you're not challenging what happened. What happens then is we ask for the state to proffer what their evidence would be. That means they make a statement to the court. If the factual basis that they recite, if that was their evidence at trial, then a person is found guilty. It's not a situation where you get to contest that. If you're wanting to contest what the charge is, that's what a trial is.
Okay, yeah, that's why if I want to do the no contents, I want to see what the state would have to say. That's what I'm trying to see if we can take care of this and resolve this, because I'm not arguing with the courts.
All right. Have you been in contact with the county attorney's office prior to the court proceeding?
No, just today, just right now. I believe I sent a copy of my documents, but I haven't spoke to them anything about anything else.
All right. The court is not a part of any negotiations that can occur between the person charged and the county attorney's office. Ms. Gillette, are you willing to speak with him if I call a brief recess?
Sure.
I didn't hear your response, Ms. Gillette.
Sure. Yes. Sure.
Okay. Mr. Curvin, if you want to speak with the county attorney about what her recommendations would be, I'm going to do what they call a breakout. And so we'll be putting this case on pause. On the screen will ask for the person to click it for the breakout room. Then that's basically a private conversation with whoever's there in the room with you and then the county attorney. It's not being broadcast out. It's not something that I hear. So I'll grant a brief continuance and we'll be in recess for that. And if the clerk would do the breakout room, please.
Okay.
All right. Record will reflect that the record will reflect that both the defendant and the state have returned from the breakout room. So we have the same appearances as before. Mr. Kervin, did you get an opportunity to speak with Ms. Gillette?
Yes, we spoke, and I believe we came up to an agreement.
All right. Ms. Gillette, is that correct?
Yes, Your Honor.
And what's the agreement as you understand it?
He's going to plead no contest to driving without a driver's license. And my recommendations are going to be a $100 fine, court costs, no jail sentence, pay in 60 days. And that if he doesn't pay, his license would be suspended. He does have a cash bond that he paid cash. He would consent to any fines and costs being taken from his cash bond. There's a form he'll need to sign at the county district court office over here, and then any difference would be refunded to him. So he does have the money here, and it will be paid out of the cash bond he has on file. I did look up; I believe it is a cash bond, and the difference would be refunded to him. Those are going to be my recommendations.
Okay, so you're recommending a $100 fine and court costs, is that correct?
Correct, Your Honor.
All right. Mr. Kervin, is that your understanding of the agreement?
Yes, sir.
Okay. Mr. Kervin, you need to understand, like I mentioned before, the court is not part of the plea negotiation process. So I'm not bound to follow the recommendations that the parties make, even when they've agreed to it. The court could sentence you to the maximum that I told you. I'm not saying that's what I'm going to do, but you need to understand that legally is possible.
Yes, sir.
Okay. With that in mind, is that correct? You still wish to proceed with a no contest plea?
Correct.
All right. Do you understand that with a no contest plea, you'd be waiving your right to a trial?
Correct.
All right. And has anybody forced or coerced you in some fashion to make this decision?
No, sir.
Very well. Ms. Gillette, what would the state's evidence be if this matter were tried?
Yeah, the defendant was driving home from Greenwood County. He had a case up there, and as he was driving home, he was stopped here in Elk County. They did not know that he had been in court up at Greenwood. He was stopped by Deputy Mike Nelson on February 6th, 3:30 p.m. on Highway 160 and 99 Junction. He was driving a 2007 BMW with a Texas plate. He had no driver's license. I don't know if he just hasn't renewed it and it's expired. Oh yeah, I do. It was expired. And he has not renewed his license. So his license is considered expired. So he had no DL, and we've charged him under 8-235.
All right. I do find that there has been a factual basis that support the charge. And I do find the defendant guilty on his no contest plea. We'll proceed at this time to sentencing. Does the state have any additional statements that you wish to make?
No, Judge, just the fine, court cost, and apply his bond and refund the difference.
All right. Mr. Kervin, are there any statements you'd like to make before I pronounce sentence?
No, sir.
Okay, Mr. Kervin, do you have your driver's license now?
It's just an occupational license that I used to go back and forth from work, but not an actual license. It's just like kind of like a work permit type of thing. And I'm not driving. I came here with my family member to bring me here to come to this court.
Okay. I'm not familiar with, is it Coolidge, Texas that you live?
Yeah, I'm in San Antonio now, but that's where I was staying at before.
Okay.
At the time.
All right. Texas requires a driver's license. And Kansas and Texas are a lot like each other in the sense that most people to get to and from work and so forth need to be able to drive. I strongly encourage you to get a proper driver's license. I'm going to pronounce sentence now. I'm going to impose a $100 fine, and I'm going to assess court costs in the amount of $108, which is the statutory amount. I've considered giving you a jail sentence. I'm declining to do so. So there's not a jail sentence imposed. However, I am going to require that this be paid. And you have cash bond that's here in Elk County, or did you post that down in San Antonio?
It was Republic. It was in Kansas where I got picked up. I think it was Republic County or something. I bailed out there.
Let me check with the clerk in a minute and see if they've got that transferred up here now. Sarah, can you answer, is there a cash bond on hand for Mr. Curvin?
Yes, sir. We do have a cash bond posted for him.
And is it in excess of $208?
Yes, sir. It was 2,500.
All right. Okay, so Mr. Curvin, following this hearing, I'm going to order that you pay that today. You have the cash bond on hand. You can come over to the clerk of the district court. They've got some paperwork for you to do in regards to that. So you'll be paying the $208. They'll be refunding the other funds to you, and that will complete this case. Again, I strongly encourage you to get a driver's license. You're a young man still. I'm sure you're going to need one for work and various things. And the vehicle apparently was properly tagged. This isn't a case where a lot of times some of these things we don't have a tag and there's no insurance, and you're not charged with those. So I'm assuming you had those things. But you can really get yourself in a bind if you keep accumulating these type of charges. And most states will generate a license for you and then suspend it, and in Kansas, I can't speak for Texas, but in Kansas, there's some mandatory jail time on driving while suspended. So, for your benefit, I'd strongly encourage you to get a valid driver's license. This matter is adjourned and the parties are free to go. Thank you.
You have some misinformed, misguided notion that the laws of the state of Michigan don't apply to you. If you got a jury summons, you wouldn't have shown up. You would have said, I'm a sovereign and you can't dictate what I have to do as a citizen of the state of Michigan. You're going to be in jail for a while. I'm going live here, so we should.
Okay, yeah, got it.
Good morning. We're going to start early. We've got some landlord-tenant matters set in. Mr. Aiken, why don't you come over here and have a seat?
Never know when you're going to need it. I never know.
Andy, I'm going to mute your mic. This is the morning we would be landlord-tenant matters here in a bit, but we've got an unscheduled matter. Mr. Justin Michael Aiken is here. File number 222036. Alleges no insurance under the insurance code. File 222037 ST alleges driving suspended first offense and improper plate. Those are alleged to have occurred on October 18th of last year. Also, the case is file 2240 SM, alleges no insurance and driving suspended on January 1st. And Mr. Aiken is here. This matter was set for jury trial on Wednesday, May 24th. Deborah Davis is here with us from the prosecuting attorney's office. She had been managing these cases, but she was obligated to try another case in the circuit court on Wednesday, very important case. And Casey Johnson was assigned then to handle this case, and he was here Wednesday, ready to proceed. We had prepared the jury instructions. We had 30 jurors here, and we were prepared to go to jury trial on the October 18th case. In your case, you had steadfastly maintained your I'm not sure, lack of responsibility. I won't say innocence, but and expressly indicated you did not want to have an attorney to represent you. And you also steadfastly remained in your request for a jury trial. And we were here. We had 30 jurors who all took the day off. And we were prepared and you didn't show up. And so I issued a bench warrant for your arrest. And I said on the live stream that if anybody knows Mr. Aiken, have him come turn himself in. And that was Wednesday. Here it is Friday morning, and here you are. Mr. Aiken, what's your position here?
Well, Your Honor, I'd like to apologize to you and everybody that was here for the trial. And I got scared that day, and I apologize to everybody for not being here. And if we could work, you know, some kind of financial plan, something of that sort, or whatever you've done, I'll get done. I'll take responsibility.
Mr. Aiken, have you paid your ticket in cold water?
I'm actually been trying to work on that.
Okay, so once that's done, you'll be able to get your license from the Secretary of State again?
Yes.
Okay.
Well, we still have these two cases, which were set for jury trial. And what do you wish to do with those? You wish me to reset them? Or is there some?
Before you make that decision, the offer of allowing another to violate the motor vehicle code in each of those, which is the offense that doesn't carry points on your license, so it wouldn't prevent you from getting your license once you pay off your cold water ticket and probably a reinstatement fee to the Secretary of State. If you pled to a count in each of the files, we would dismiss the remainder.
All right, that was the original offer, and she bent over backwards to make it. So let me repeat what it is. You're charged with two separate incidents: driving suspended and having no insurance. No insurance is punishable by up to a year in jail. It carries a minimum fine of $200, a maximum fine of $500. It requires you to be fingerprinted, and it doesn't have a restriction. The driving suspended charge requires that your license be suspended. It carries 2 points, fine of up to $500 and up to 93 days in jail. The prosecutor is agreeing to dismiss all of that, plus the plate violation, for 2 pleas to allowing another to violate the motor vehicle code. Allowing another to violate the motor vehicle code is sort of a legal fiction. The other that it is allowing to violate the code is yourself. But it carries no points. It doesn't get abstracted to your driver's license and won't affect your ability to keep or maintain your license. Ms. Davis had made that offer at least twice before, and you declined it. Are you willing to accept that at this point?
I'm willing to accept that, Your Honor.
All right. Did anybody promise you anything to get you to plead to this?
No.
Diana, you need Debbie?
I just need a signature. Thank you, Judge.
Sure.
I'm sorry.
You can keep that.
Am I back?
No, actually, no, I need it back. I just thought you might need a pen.
I don't typically go paperless, but that's an amended information or amended.
All right, Mr. Aiken, let's talk about that. Other than what Deborah said and what I just explained to you, did anybody promise you anything to get you to plead to this?
It was all me just wanting to get this taken care of, and it was all.
All right, anybody threaten you?
No, sir.
Do you understand that if you do plead to these charges, you'll be giving up your right to have a trial in front of a judge or jury?
Yes, I
If you had a trial, you would have the right to be represented by an attorney. All you gotta do is ask me, but you've been adamant throughout that you did not want to have an attorney to represent you. If you had a trial, you'd have a right to have any of the witnesses for or against you subpoenaed to come to court so that you could be questioned under oath. You would have the right to take the witness stand yourself and testify, but you don't have to because you have a right not to testify. And if you did not wish to testify, the judge or jury could not hold your silence against you. And you have the right to be presumed innocent if and until the state was able to prove your guilt beyond a reasonable doubt. You understand?
Yes, sir. I was driving.
Traveling. Well, did you not have a?
I just purchased that.
It was a truck.
Yeah, it was a truck.
All right. I'm going to order a $75 crime victims' rights fee, $50 state minimum fee, $125. I'm going to give you until July 1st. All right, that takes care of the first case. An order 10 days jail, credit 0, leaving 10 days to serve. Same thing, $125, due by July 1st of 23. I also find that you're in contempt of court for failing to appear for your jury trial on Wednesday. You have some misinformed, misguided notion that the laws of the state of Michigan don't apply to you. People refer to this as sovereign citizen, but that isn't what it is. There's no sovereign in it. I call it willingly misinformed defendants. There's no sovereign about it. And you wasted a whole bunch of our time, the prosecutor's time, filed a bunch of documents that didn't mean anything. You were always respectful, but she made this very generous plea offer several times, but you wanted to represent yourself. You wanted to have a jury trial. The irony of this is that you demanded your rights as a citizen in the state of Michigan to be presumed to be innocent, to have an attorney appointed, and to have a jury of your peers. If you got a jury summons, you wouldn't have shown up. You would have said, I'm a sovereign and you can't dictate what I have to do as a citizen of the state of Michigan, but you're okay if you drag in 30 other people who took the day off work, who were nervous the night before. They came in here and sat around here for waiting for you to show up, and you wouldn't have shown up if you had been a juror. It cost the county $565 in jury fees, and it cost the jurors probably thousands of dollars to come in here for your foolish request. So the contempt was committed in my presence. I'm going to do it in the other case, 232036. You had been respectful, but that's disrespectful to me, to the prosecutor, and to all those private citizens that came in here because of your whimsical, and I don't even know if they were sincere beliefs. Whoever sold you on this foolishness is cynical. They don't even believe it. I don't know whether you believe it or you're just like messing with the system. But when you involve 30 or 35 of your common citizens who get dragged into this, it's no longer polite or respectful. And you could have had a trial. They would have been here. It would have taken Mr. Johnson about a half an hour to put in the proofs. I also understand, Deborah, he may have 4 or 5 warrants out of Elkhart County, Indiana, and a non-support warrant wanted in Indiana. and we'll explore that. For the contempt, I order 30 days, credit 0, concurrent with the 10 days I gave you on the other case. And the cost of the juror to the county,
It appears there's 5 separate warrants out of Elkhart for same charge each time, invasion of privacy, violating protective order.
As of January this.
I don't know, but there's
I mean, they're all
apparently warrants
from
for your
20.
arrest. Now, darn it. It was Wednesday, she said that. 2405. So you'll $525 restitution for the cost of the jury. You got a sweet deal from Miss Davis. My advice to you is you get a driver's license like everybody else, like all those jurors that came in here to hear your case.